Colegas.
Colleagues, a very good afternoon. I'd like to welcome our visitors, representatives of civil society who have joined the meeting. We will now proceed with our public meeting to continue analysing the draft general comment number 36 on the right to life. As you will recall, our two rapporteurs are Sir Nigel Rodley and Mr. Yuval Shani, and they have presented a first draft to us for discussion at first reading. This draft has raised a great deal of interest. At the first meeting that we held during this session to discuss the draft general comment, all colleagues took the floor. All colleagues thanked the very great efforts made by the rapporteurs, and all colleagues made general comments. We then moved to looking at the first few paragraphs of this draft general comment. Regarding paragraph 2, there were various statements made, and based on those, our rapporteurs have sent us a further draft which you should have before you. New paragraphs for discussion in first reading. The text is only in English, but the rapporteurs have been kind enough to set out in bold the new text for those who don't have English as a working language. So the changes and new issues are in bold in the new text. We have a list of speakers who wanted to speak on paragraph 3. I have on my list Mr. de Frouville, Mr. Fatala, Mr. Sejal Singh, Ms. Cleveland, and Ms. Libet 4. They had all requested the floor when we ran out of time the last time. First of all, then, I'll give the floor to the rapporteurs for them to guide our proceedings. Mr. Shani, you have the floor.
Thank you, Mr. Chair. So, as indicated, we have circulated new language for paragraph 2, which is based on the comments and suggestions that were made on the floor. And if you allow us, Chair, I would first like us to approve paragraph 2 and then proceed to the discussion we already started with respect to paragraph 3. So I apologize for the confusion, but we have to go a little bit one step back and one step forward in order to eventually get all things done in the right order. So maybe I will survey the changes that have been made, and then we can perhaps discuss them. So with respect to paragraph 2, the first change that has been made was to replace the term individuals with the term human beings. I'm noting these changes partly for in order to allow those who do not work in English also to get the translation for the specific terms. Now, Mr. Bouzid made a proposal that we would add to the first sentence the term without discrimination of any ground. I did leave these words. We did leave these words in square brackets, not because we disagree with the proposal, but because we would want to propose to the committee to integrate this notion in paragraph 3, which also deals with the protection of the right to life to all individuals. So I would propose, when we get to paragraph 3, to introduce this concept in the last sentence of paragraph 3. and in fact, the same proposal will be made with respect to the last phrase that was proposed by Madame Cleveland, and it is also in square brackets, again, not because we disagree with the proposal, but rather because we think it would work better in paragraph 3. The remaining issues that were raised were it was proposed that the notion of derogation would be explained further, so it would cover times of war and other public emergencies. This is a text which goes a little bit beyond Article 4, which doesn't mention war, but the issue of war was important to flag for some members, and we accepted this. And then there was an attempt, I think Mr. Fatala was central to that attempt to strengthen the last sentence by emphasizing the inherent nature of the right to life and the fundamental aspect to this. So I will read the last sentence as it currently is proposed. It is most precious for its own sake, as a right that inheres in every human being, but it also constitutes a fundamental right without which the enjoyment of all other human rights could not be guaranteed, full stop. So the proposal we have is to adopt the paragraph as is without the square brackets, and to integrate both texts in the square brackets in paragraph 3, which we will momentarily get to. And this is what I had to say, and now I will propose that Sir Nigel will pick it up from here. Thank you.
Sir Nigel tiene la palabra.
You have the floor, sir.
Thanks, and not much to add other than to indicate that I have a feeling, given the way the discussion of paragraph 3 was going, that we might actually end up wanting to integrate paragraphs 2 and 3, combine paragraphs 2 and 3 into one paragraph, which was another reason for keeping those texts in square brackets. So, subject to that, I would support my co-rapporteur's view that if it's convenient to the committee, it might adopt paragraph 2 now, bearing in mind exactly the points made by Mr. Shani, and indeed the point I've just made too. But equally, if we wanted to finish paragraph 3 as well and do both at the same time, that would also be okay. But certainly we'll have a clearer view if the committee does, as Mr. Shani asks, which is adopt paragraph 2 right now. Thank you very much, sir.
Muy bien, muchas gracias.
Okay, great. Thank you very much. We will proceed as suggested by the co-rapporteurs. Is paragraph 2 in the new version presented to us by the two rapporteurs, is that acceptable to the committee? We need to take into account that what is in square brackets currently will be moved to paragraph 3. And perhaps these two paragraphs might ultimately be merged. I see no objection. With that, we can adopt paragraph 2. Mr. de Frouville.
Pardon, Monsieur le Président.
Chairman, I hadn't understood that we were adopting paragraph 2 already, because I did have comments to make, both on the substance and also on the language, because there would perhaps be difficulties in the French version, so I think it would be worthwhile opening the paragraph for discussion, even just for a short while. But I'm in your hands, of course.
Muchas gracias.
Thank you, Mr. de Frouville. Well, yes, I was, in fact, asking whether people agreed, and those who didn't were, of course, able to take the floor. If you wish to take the floor in paragraph 2, then I invite you to take the floor. You have the floor. Thank you, Chairman. Of course, I'm working both with the French and English versions. I think it is important to ensure consistency between the two texts. The first change creates no problem. Human beings, we do have personnes humaines in French, and so we can indeed add that in. We might also come back to what Mr. Fatala proposed and talk about all human beings, toutes les personnes humaines. It would be possible to add in a discrimination clause. Now, I understand we've got that in square brackets, depending on the discussion that happens under paragraph 3. On the proposal regarding public emergencies, I mean, that's not entirely the language of the covenant, the circonstance exceptionnelle in French, but I do think it is appropriate. For the rest, on the notion of the fundamental character of the right to life, I think the term fundamental, which has been added in the English, that can translate into the French without a problem, but it might require additional comment. I think what's very important in this paragraph is that we are dealing with something that is fundamental that may also be dealt with in paragraph 3, but I prefer to talk about it here because it's not very good if we replace indivisibility and interdependence of human rights with the term fundamental. Now, I insisted on this last time. There isn't really a hierarchy among human rights. Now, there is an interdependence of human rights, and we can say the right to life is a condition for the enjoyment of human rights, but I think it would be useful here to incorporate the idea of interdependence. We also need to say that other human rights enshrined and recognized in the Covenant and in other instruments are a condition for the effective enjoyment of the right to life. So there is really a true interdependence and a kind of reciprocity. I would perhaps even add an additional sentence in to get this idea of interdependence across, with the idea of the right to life being a fundamental right, but also the inverse idea that other human rights contribute to the full enjoyment of the right to life. Of course, we'll talk about in paragraph 3 dignified life or dignified existence, and I think that's important, but I do think they're linked. Thank you very much for giving me the floor, sir.
Muchas gracias.
Thank you very much, Mr. de Frouville. I'd like to remind you that colleagues, the co-rapporteurs did say that perhaps paragraphs 2 and 3 might well be merged. They might well be combined. That's what both Mr. Shani and Sir Nigel did say, so that we can bear that in mind. But I'm sure the rapporteurs have taken note of your views. Mr. Fatala, please.
Merci, Monsieur le Président.
Thank you very much, Chairman. Chairman, I completely agree with the new text proposed for paragraph 2, but I would have a question. You said that the sentences in square brackets will be moved to paragraph 3. I'd like to know where and how, because I don't actually understand how they would fit in. So if you could clarify that for me. And the last point raised by Mr. de Frouville regarding the interdependence of the right to life and all other fundamental rights in order to guarantee the right to life, I think that's essentially paragraph 3, which talks about dignified existence. And if the two rapporteurs intend to merge paras 2 and 3, then I do think that it will be complementary, and Mr. de Frouville's idea will be covered in this when the two paragraphs are essentially combined. Thank you, sir.
Muy bien, muchas gracias.
Thank you very much. Mr. Benachor.
Merci, Monsieur le Président.
Thank you, Chairman. First of all comments regarding the drafting of the French version that we'd worked on the last time, we can no longer discuss them today because the paragraphs that we've been given are in English. So we would need to wait for the French translation of these new paragraphs in order for us to discuss the French version again. I'll leave that point there. Secondly, I would like to make a general comment at this stage. I believe, like Mr. de Frouville, in the interdependence of human rights. But I'd also like to say that I don't believe in the idea of a lack of hierarchy among human rights. I think there is a hierarchy. I think there is interdependence, yes, but I think that there is a hierarchy among human rights. There are fundamental rights without which no other right is possible. For example, the right to life. That isn't the case for some other rights which are guaranteed in human rights treaties. But that is an academic discussion. I can leave that to one side for now. I think that what Mr. Fatala has said is right. If we merge paragraphs 2 and 3 as proposed by Sir Nigel, then the problem is perhaps solved. We will have the idea of interdependence covered by that. Thank you.
Est-ce qu'on pourrait savoir quand on pourrait avoir...
Could we get an idea as to when we can get the French translation of the new paras? No?
Gracias.
Thank you.
El señor Benachur sabe y saben.
As Mr. Benachur and I'm sure all colleagues are aware, it is not possible for us to get an official translation of this type of text. Generally speaking, we do what we did with the previous general comment. We only get them in the working language of the rapporteurs. What we might be able to do, and I might ask the rapporteurs if they can help, is we might be able to have them read it at dictation speed so that our interpreter colleagues can interpret the text into Spanish and French simultaneously. But given the resource constraints that we're all aware of, we're not able to send such text officially for translation or proposed amendments. Once the text is approved, once the document is adopted after the first reading, then the new version, the new adopted version, will be translated officially into the working languages. Mr. Politi, please.
Thank you. Thank you, Chairman. I agree with the text that's been proposed by the two rapporteurs. I'm talking about paragraph 2, and I obviously look forward to see how it looks like when combined with paragraph 3. I just want to pick up briefly on the notion of interdependence and the suggestions made by Mr. de Frouville. Perhaps one way of dealing with this notion of interdependence would be to say something like this. I'm talking about the last sentence of the current paragraph 2. It is most precious for its own sake, as a right that inheres in every human being, but it also constitutes a fundamental right whose effective protection is a prerequisite for the enjoyment of all other human rights. That would be one way. I don't see how the current paragraph 3 could take care of this. The notion of being a prerequisite for the enjoyment of all other human rights could be the way to deal with this notion of interdependence. Thank you.
Muy bien.
Thank you very much. Mr. Sichel-Singh, please.
Thank you, Chairman. In fact, Mr. Politi has made the point I wanted to make because I have a slight problem with the word guaranteed in the penalty-made sentence, where we say, but it also constitutes a fundamental right without which the enjoyment of all other human rights could not be guaranteed. And I was going to suggest something on the same line, but it also constitutes a fundamental right without which all other human rights cannot be enjoyed, to introduce this notion of prerequisite. Because, of course, one can be alive but not enjoy other human rights or not enjoy any human right at all. And this explains my difficulty with the word guaranteed. Thank you, Chairman.
Muy bien, muchas gracias. Si nadie...
Thank you very much. If no one else wishes to take the floor, I would like to speak in my personal capacity now as Mr. Fatala, please.
doy la palabra a usted.
I give the floor to Mr. Fatala.
Monsieur le Président, puisque la dernière phrase était ma proposition,
Chairman, given that the last sentence was my proposal, I don't have a problem with putting realised instead of guaranteed. Yesterday, when I read this, I said invoked, addressed, I used several terms, but the term which is most all-encompassing with regards to the ideas raised by colleagues, well, I don't really have any other options for guaranteed in English. Given that we're talking about the right to life, I think what Mr. Benachur raised, the idea of a supreme right, this is reflected in the text itself, because the second text begins, it is the supreme right. And I think Mr. de Frouville had no problems with leaving the idea of supreme right in there. Thank you, Chairman.
Muchas gracias. Señor de Fruil.
Thank you. Mr. de Frouville, please. My apologies for taking the floor again, Chairman. I simply wanted to support what Mr. Sital Singh had said. I think his proposal in place of guarantee is much more appropriate. It's not a matter of guarantees, he's quite right to say so. Secondly, in terms of procedure, I had indeed agreed that those paragraphs might be merged, but that was the reason for me to say that we could not adopt paragraph 2 because that was dependent on the examination of paragraph 3. We cannot know what the content of 3 will be, so as such we cannot adopt 2. Thank you. The Chairman, thank you very much indeed, Mr. de Frouville. I'm grateful to you for your help. Thank you for helping me out in my work. You're absolutely right. We will not adopt the paragraph as it stands. We'll leave it pending for the time being. I would now like to speak in a personal capacity to point out one issue. I think it is very right to make reference to interdependence and indivisibility of human rights. It's also, I believe, right for there to be a reference to the fact that the right to life is a prerequisite for the enjoyment of all other human rights. That's not only the case for the right to life. Many rights can be considered as sources of the enjoyment of other rights, or as rights that enable better enjoyment of other rights. I do think it is essential for there not to be any reference to a hierarchy of rights, because that could lead to doctrinal debate. A number of authors believe that rights cannot be ranked in this way. On the other hand, the notion of independence and indivisibility of rights is something that has been very much enshrined in various international instruments, including the Vienna Declaration and Programme of Action adopted by the World Human Rights Council in 1993. And I would like to give the floor to Mr. Shani on this note, please.
Thank you. I will not delve into this doctrinal debate, although I have some question mark as to whether the right to life and the right not to be imprisoned for a civil debt are on the same normative rank. But I'm going to be focused on the on the text before. So if I understood correctly, Mr. Sital Singh's proposal would be to change the sentence from without which the enjoyment of all human rights couldn't be guaranteed, to without which all other human rights could not be enjoyed. And I understand that this is also acceptable to Mr. Fatala, and I think this is also, I'm trying to find my co-rapporteur's eyes, but I think it is also acceptable to us. So this is the first point. The second point, with regard to the point of procedure, I accept that, well, hopefully we will get also paragraph 3 done so we could adopt both paragraphs, and because I didn't want to leave too many paragraphs hanging in the air. So if we get to the end of the session today, to get to the end of the meeting today, and we will still not finish with paragraph 3, then we will return to review this. So for the time being, maybe it's wise not to adopt it. Now, with respect to the point made by Mr. de Frouville about adding on the issue of interdependence in this context, I am not opposed to adding this idea, but we will have, of course, then to think of a specific formulation, and I may consult with Mr. de Frouville, and again, we could bring this to the floor. So even if we would adopt paragraph 2, it would be provisionally, so that I think it could be useful when we are talking about this being a prerequisite for other rights, that it is also informed or infused by other rights, and we will think of a proper formulation that would convey the message. I just want to draw the committee's attention to the fact that we have a whole chapter in the end of the draft general comment, chapter 4, which deals with the relationship between Article 6 and other provisions of the covenant, and actually underscores the notion of indivisibility, although frankly it focuses on other provisions of the covenant and doesn't deal with provisions taking from other human rights instruments. Therefore, I'm not opposed to, when we are presenting the article, to lay a broader spectrum of issues. I think I will stop now and suggest that maybe Sir Nigel will pick it up from here.
Lo escuchamos a Sir Nigel.
Let's listen to Sir Nigel. Sir Nigel, you have the floor.
Thank you, sir. I am happy to get rid of the guaranteed and replace it with enjoyment. I guess I actually slightly preferred, with the greatest of respect to Mr. Sital Singh, Mr. Politi's version of the same thing to that of Mr. Sital Singh, that is, whose effective protection is a prerequisite for the enjoyment of all other human rights. I think that captures the same idea, but it captures it in terms that resonate better for me in English, though we're talking about the same thing as far as I'm concerned. I do think that it's bearing in mind what we've just said, and bearing in mind that we have also agreed with our predecessor committee already in the first sentence of paragraph 2 that it's the supreme human right. We had better be very careful that any reference to interdependence and indivisibility doesn't end up turning that on its head. And if it even began to do so, this particular member of the committee would find it very difficult to go along with. I suspect that what we should be doing now is suspending discussion on paragraph 2, continue the discussion on paragraph 3. I feel we might have facilitated the task of the committee better if we'd just gone straight ahead, continuing the discussion on paragraph 3. I apologize that that talk of combination may have confused us a little bit. But I think once we've agreed on a content for what is now paragraph 3, bearing in mind what I think we probably understand by what should be in paragraph 2, we'll then be in a position to come back and provide for the committee either 2 paragraphs or 1 combined paragraph. So the recommendation from this co-rapporteur is that we now proceed with the continuation of the discussion on paragraph 3. Thank you very much, sir.
Muchas gracias, Sir Nigel.
Thank you, Sir Nigel. Can I make a suggestion to committee members? And it's as follows. It's very hard to try to have an 18-person drafting committee, virtually impossible. I have participated in the adoption of 2 general comments, 34 and 35, and though on a number of occasions I wasn't in agreement with the exact words being proposed by the rapporteur for given paragraphs, if the paragraphs reflected the meaning that I felt needed to be included, I preferred not to take the floor, because that would have made the rapporteur's work much harder. I do, of course, want to avoid cutting off anybody's right to take the floor to make suggestions, but I'm just thinking about the rapporteurs and assisting their work. If we believe that the proposals from the rapporteurs capture the general sense that we would like to see in the paragraph, can I encourage us all to adopt the wording as put forward by the rapporteurs? I say this because I think we need to move a little bit more quickly. I know we've only just started. It takes a little while to get warmed up. But I am thinking first and foremost about assisting the rapporteurs in their task. With that said, let's move on to paragraph 3. Mr. Shani, please.
Thank you. I very much appreciate your last set of comments. Think of the rapporteurs, my friend. So with respect to paragraph 3, we've already started discussion. Let me just, and we've already introduced the paragraph. Let me just answer the question proposed by Mr. Fatala with respect to the square brackets. What is it that we propose? So our proposal would be to start the paragraph with the last square brackets, which are in the new language for paragraph 2. Namely, it's currently read, it is a right which should not be interpreted narrowly. So we would propose to start the paragraph, the right to life is a right which should not be interpreted narrowly. This is language drawn up from General Comment 6. And then the second sentence would start, it concerns, and the rest will continue as it currently reads. So the idea would be to start with, it is a right, the right to life is a right which should not be interpreted narrowly. It concerns, etc., etc. And with respect to the proposal made by Mr. Bouzid, the proposal would be to introduce this in the last sentence of paragraph 3, so that the last sentence would read, Article 6 guarantees this right for all individuals without distinction of any kind. Language taken from Article 2, Paragraph 1 of the Covenant, and then including, it should be then 4 persons suspected, etc., etc., although we've discussed whether we want to keep this segment. If we introduce Mr. Bouzid's proposal here, it will be easier for us to erase the last segment of the sentence if we so choose. And in that case, it will simply read Article 6 guarantees this right for all individuals without distinction of any kind, full stop. However, Mr. Ben-Achour expressed last time preference for keeping the remainder of the sentence, and we are, of course, happy to go whichever direction that the committee feels is appropriate in that regard. Thank you.
Muy bien, muchas gracias.
Thank you very much indeed. We'd already started to hear some comments on this paragraph. We ran out of time. I have 7 requests for the floor, and the first speaker is Mr. de Frouville.
Merci, Monsieur le Président.
Thank you, Chairman. I'd forgotten that this was a list that you'd kept from last time round. Now, with regard to paragraph 3, first, we have a translation issue. I'm not going to come back to language issues on a systematic basis. I'm going to note them down and flag them every so often. Talking about the notion of individuals in English on the one hand, and personne humaine, human person, in the French. Sometimes they're equivalent. Individual and person, depending on the context, may be equivalent. On other occasions, they are not. One needs to be careful because a person can be a legal or a natural person. A person, as opposed to an individual, may lead to a potential reversal of meaning, given that you can have both the legal and natural persons, and we might be extending the right to life in directions that were not entirely intended. So that's the first point in the first line. So, toute personne or tout individu, that question in French. Turning to the content now, what's going to become the second sentence, bearing in mind the amendment proposed by the rapporteur. Well, but now the first sentence generally describes the content of the right to life. Freedom from acts and omissions intended to cause unnatural or premature death, as well as a legitimate expectation and so on. I don't know about the English version exactly, but this sentence in French is too long. It needs to be cut in two. Two sentences need to be made out of this to make it clear that there are two areas of content of the right. Firstly, the right to life covers the entitlement of all individuals to be free from acts and omissions. I will come back later with a proposed amendment. And then a second part of the content of the right relating to dignified existence. So my first proposal would be to cut those two elements into two separate sentences such that it is clear, since as it stands it is not clear, in French at least. I now move on to two proposed amendments, at least in the French version. In the first sentence, the first element of the right in French, individuals free from acts and omissions intended or expected to. In my opinion, that isn't included in the English version, says the speaker. Escompté or expected seems to entail a result. It seems that the rapporteur is trying to reflect the fact that actions that take place that are not necessarily intended but may lead to the deprivation of life. This may be an action or omission which is intended or whose goal is to bring about death. It might be an omission whose result objectively is that death, on the other hand. So it's important to get rid of the term escompté in French. Turning now to dignified existence. This is a concept that comes from the Inter-American Court of Human Rights. I looked for the French translation. I couldn't find one which entirely satisfied me. Could I propose the version vie dans la dignité, life in dignity, the right to all individuals to live in dignity, because dignified existence is a little bit ambiguous. It's open to value judgments. Dignity can be viewed subjectively as well as objectively in terms of the need to respect the dignity of the person. Dignity might entail honor also, for example, with regard to belonging to a particular social class or having been awarded a particular merit of some kind. So I think there's a risk of potential confusion with this subjective notion of dignity. And I think living in dignity would help us to avoid that problem. As I said, though, these are problems which pertain essentially to the French version. I'm sorry to mention those, but I wanted to flag them at this stage. Thank you. Thank you very much indeed, Mr. de Frouville. To all those who might be interested in delving further into this concept from the Inter-American Court, can I suggest that you examine the Villa-Gran Morales et al. Against Guatemala with regard to street children? This was ruled upon on the 19th of November 1998 by the court. I'd now like to give the floor to Mr. Fatala, please.
Thank you, Mr. Chairman. Mr. Chairman, I have two comments on paragraph 3. The first one, I believe that we should introduce in the first sentence, either after or before what we decided already to introduce from paragraph 2, which is it is a right which should not be interpreted narrowly. I think that it's more important to put the concept which is in Article 6, that this right, the right to life should be protected by law. I think that the concept of the protection of the right to life by law should have its place in the first sentence of 3. I was trying to check if it is further down in other paragraph, but I was not able to retrieve it. Maybe it is someone else, but I think that the right place is to put it in the first sentence of 3. The second, my second comment relates to the last sentence of paragraph 3. And I would propose also to delete such terrorist crimes, because it's enough to speak about including persons suspected or convicted of serious crimes. We don't have to give an example or to enumerate, because at the end, serious crimes is very clear for us, and it shouldn't be. We shouldn't give the example of just terrorist crimes. Thank you, Mr. Chair.
Muchas gracias, señor.
Thank you, Mr. Fatala. Can I now give the floor to Mr. Situl Singh?
Thank you, Chairman. The proposal of Mr. Shani to introduce that sentence, it is a right which should not be interpreted narrowly. I think that's a good proposal, and I would agree with Mr. Fatala that we should add this is a right that should be protected by law. We'll leave the drafting to the rapporteurs if this is agreed. I was coming to the point about dignified existence, and I actually like this expression, but it may give rise to debate at this stage. But I shall draw the attention of the committee to the fact that the rapporteurs in paragraph 28 have introduced this notion in this very interesting paragraph 28, which, as I said yesterday, is actually encompasses too many ideas and could be broken up later, but we'll deal with that later. And as you've said, Chairman, in footnote 102 in paragraph 28, top of page 10 in my draft, there's the case you referred to is in the footnote, Morales, Guatemala. And so dignified existence does mean quite a lot of things, and as was pointed out yesterday, in the preamble to our covenant, there's a reference to dignity in the first two preambular paragraphs. And then in the third paragraph, there's also this link between civil and political rights and economic, social, and cultural rights. And actually, this is going to be the theme to celebrate the anniversary of the two covenants, as from 10th December this year, the themes of freedom from fear and freedom from want. Now, if we don't want to get into the debate about dignified existence at this stage, then I would agree that we could say to enjoy life with dignity, and we can leave the notion of dignified existence to when we come to paragraph 28. But I must also add that in General Comment 6, paragraph 5, in the General Comment of 1982, there is this notion that the state should adopt positive measures. And one example was given in paragraph 5 of General Comment number 6, for instance, that state parties should take all possible measures to reduce infant mortality and to increase life expectancy. especially in adopting measures to eliminate malnutrition and epidemics. But as I said, well, we can't afford in the introductory paragraphs of our general comment to engage in all this, and we can leave it for later. But the idea is already there. And by the way, I don't know whether later on we can perhaps make a reference to the SDGs, because now the SDGs, we must sure that we are aware of the SDGs when perhaps we come to paragraph 28. And finally, concerning the last sentence as a matter of substance, I would agree that we should stop that at Article 6 guarantees this right for all individuals without distinction of any kind, because in the opening paragraphs, I am of the view that we should not engage into the debate about the death penalty. We could leave this for later on when we come to dealing with the death penalty. And if we want to keep it, then the other option would be to say Article 6 guarantees this right for all individuals, including persons suspected and convicted of most serious crimes, and not just serious crimes, most serious crimes, as pointed out in Article 6, and stop there without going into a categorization of terrorist crimes. But I would prefer my first option, that we stop at without distinction of any kind. Thank you, Chairman.
Muchas gracias.
Thank you very much, Mr. Setul Singh. Thank you also for pointing out the footnote references. If I could remind colleagues working with the Spanish or French versions to have the English version in front of you at the same time, because the English version does have the footnotes, which are not included in the French or Spanish versions. Could I now give the floor to Ms. Cleveland, please?
Thank you, Mr. Chairperson. I'll respond to a couple points that have been made and then offer a few others. With respect to Mr. Fatala's proposal of adding a reference to protection by law at the beginning of paragraph 3, I was actually going to ask that we add that language as well as a reference to the fact that no person may be arbitrarily deprived of life at the beginning of paragraph 4, because paragraph 4 outlines the content of Article 6, and otherwise we do not reference either the fact that the right to life must be protected by law or that no person may be arbitrarily deprived of life in these opening paragraphs, and I think they're important limitations. So I don't actually have a strong preference whether that is at the beginning of paragraph 3 or 4, but I think it should be in the introductory paragraphs. With respect to the language that Mr. Dufreville flagged in the second line of the paragraph, acts or omissions intended or expected to cause their unnatural or premature death. I was wondering if there's a space between intended or expected to cause death on the one hand and legitimate expectation on the other that is not captured by this language. In other words, what about acts or omissions that are reasonably foreseen to cause unnatural or premature death? So I'm not entirely sure what work is intended to be done by intended or expected in that sentence. It could be that we could just say, we could omit it altogether and say the right to be free from acts and omissions that cause their unnatural or premature death. But if not, I might suggest that we add something like or reasonably foreseen after expected. On the issue of the last line and the reference to terrorist crimes, I was very sympathetic to, I believe, Mr. Politi's view, or I believe it was him in the last session, that we should retain the reference to terrorist crimes because it is common in the present day, unfortunately, to see people in my country and others take the position that persons who are suspected of terrorism are not entitled to rights protections, including rights under this covenant. Although if we keep terrorist crimes, I would be inclined to also reference something else, such as international crimes in general, so we're not singling out terrorist crimes. But Mr. Fatala's suggestion that we just put a period after serious crimes is attractive to me, because I think it would implicitly cover all such crimes, and it wouldn't date this general comment to the particular moment that we were in. So I support Mr. Fatala's suggestion. It could be the most serious crimes, as Mr. Sichel-Singh suggested. And then finally, with respect to the dignified existence, dignified life discussion, I thought that this draft reached a appropriate balance in that regard, and I thought it was quite carefully done, and I commend the rapporteurs for their efforts. I did not read this as suggesting that we were incorporating in whole cloth the approach of the Inter-American Court to a dignified existence, and I think it's clear that we are operating in a somewhat different treaty structure. The right to life is one right among many in this covenant, and there is also a separate covenant protecting economic, social, and cultural rights. So we are not in the situation of either the Indian Supreme Court or the Inter-American system, where the right to life may need to bear a more expansive reading. And it is also a non-derogable right in our covenant, and I think we need to keep that in mind so that we don't try to read into it obligations that can and should be derogable in certain circumstances. So I support the way that it is framed at this time for those reasons. Thank you.
Muchas gracias.
Thank you very much indeed, Ms. Cleveland. Ms. Zybit-Four, please.
Thank you very much, Mr. Chairman. I would like to point out 3 points. First of all, I would like to highlight over here that Article 6 has different pillars, and perhaps we should stress more that we have different pillars over here that we are dealing with.
I'm sorry, there is no translation to Spanish. Okay. Ya tenemos.
We have it now. No problem. Ms. Zybit-Four, please have the floor.
Thank you, Mr. Chairman. I would like to stress that Article 6 comprises various pillars, and perhaps we could make it a little bit more apparent that different pillars are involved over here. I'm a little bit afraid that the first sentence, which makes reference to the different pillars all at the same time, which is the freedom to be free from acts and omissions, is perhaps a little bit too broad in the way that it's drafted over here. I would rather have 2 sentences, which first of all deal with the deprivation part, which is outlined in Article 6, paragraph 1, and then with the omission part, which is in effect about due diligence and the protection of the right to life, and which is later then elaborated on in the subsequent chapters. So I think it would be more appropriate, instead of having one sentence which catches both aspects and seems to apply the very same standards, to separate these 2 pillars in order to make it more explicit and then have the references to the respective paragraphs. With regard to the issue of dignity, I would also like to stress that we should make reference to human dignity in this covenant, but in this general comment, but I also see the problems that some members of the committee seem to be raising yesterday. So I thought perhaps we could tie it a little bit more to the text of the preamble of the ICCPR, and therefore have as a third sentence something along the following lines. The right to life is the foundation of the inherent dignity of each human being. That would be in line with the general, with the preamble, and therefore would underline the importance of the dignity of each person. Now, with regard to the wording, I thought that yesterday we had agreed on not to use the term individual, but to replace it by human being, and I would advocate doing this also in the other paragraphs. So I take that the proposal put forward by Mr. Chani at the very beginning would then read Article 6 guarantees this right to all human beings without discrimination, so on and so forth. Final comment on the final sentence of this paragraph. I can see that this sentence is probably causing more problems than it solves. For me, it is absolutely clear what the sentence says. However, by explicitly making reference to it, a reader may say, okay, so there's one example, what about all the other examples? So I'm a little bit afraid that by just making reference over here to serious crimes, such as terrorist crimes, I think we may give the wrong impression. Therefore, I would support the chairperson as well as Mr. Rodriguez-Rasca that perhaps we don't need to have Article 6 because it is clear that these persons are included. Thank you.
Muchas gracias, señor.
Thank you very much, Ms. Seibert, for Mr. Vasilashvili, please.
Thank you very much, Chair. Well, I'll start with the last point made by Ms. Seibert, and I think I would agree with the suggestion made posed by Rapporteur and Mr. Bouzid to include the reference to all kinds of individuals, and I would also be in favor of stop putting dots at the when we speak about the serious crimes and not make a reference to the specific crime of terrorism. Although we may come back to this probably somewhere down in the general comment and touch the terrorism acts and the response of the state to the terrorism acts. So we don't. If we make an exception here in the very beginning, it may really make some confusion to the readers. I would also agree with Mr. Fatala's suggestion to refer to the need to protect the life protected by the law. With regards to the dignified existence or the life with dignity, well, I'm somewhat sympathetic with the proposal made by Ms. Seibert because I also felt that it's the dignified life. It covers. This is a concept which is much wider than the right to life as protected by Article 6, and I think Mr. Yosawa was making similar point last time. Although I understand that we need to make a reference, or it seems that the drafters implied that individuals should be free from fear as well, from the fear fear that their lives would be taken away arbitrarily, or they should not be exposed to the regime which disregards the value of life and really can take life from the individuals capriciously or arbitrarily. So this is something probably we should be referring to, but using probably different terms rather than dignified life or life with dignity. I think that's it, what I want to say. Thank you.
Muchas gracias.
Thank you very much. I have 5 further speakers on my list. Mr. Bouzid, please.
6.
شكرا سيد الرئيس.
Thank you very much, Chairman. On a dignified existence or dignified life or life in dignity, this is a good term, but it's quite a general one. We need to be more specific. We need to talk about the state's obligations in this area. We might say that the state has a duty to offer or to provide the basic conditions for life, such as health care, food, and so on. The reference should not be a general one. We need to be more specific, and we do need to mention the state's obligations in this area. Thank you.
Muchas gracias, señor.
Thank you very much, Mr. Bouzid. Mr. Benachor, please. Thank you, Chairman. A number of comments that I wanted to make have already been made, so I won't go over them again. I just wanted to insist that we keep the last part of paragraph 3, namely the specific reference to the terrorist crimes, especially given the current trend of some states. You'll recall that there are, in fact, several states, not just those that we've seen recently, but there are several states which have been reintroducing the death penalty for terrorist crimes almost systematically. And I do think it is, therefore, worthwhile keeping terrorist crimes, a reference to terrorist crimes, as part of serious crimes. I'll leave it there because my colleagues have said everything else I wanted to say. Thank you very much, Mr. Beneshur. Mr. Fatala, please.
I'm sorry, Mr. Chairman, to take the floor once again, but it's on two issues, or at least one issue. The issue which was raised by Mrs. Cleveland concerning my proposal to add the notion of protected by law. I propose it to have it in 3, not in 4, for a very simple reason, that in 4 we are making reference to paragraph 2, 4, 5, and 6 of Article 6 of the Covenant, set out specific safeguards. And the issue of protected by law is in paragraph 1 of Article 6, and it is a general notion and not addressing specific safeguards. This is just my comment on what has been said to make it clear why I made it to be introduced in 3 and not in 4. For the moment, that's the only comment I have. Thanks.
Thank you very much, Mr. Fatala. Mr. Iwasawa, please.
Thank you very much, Mr. Chair. With regard to the last sentence, everybody has already said what I want to say, but I agree with the addition of without distinction of any kind, but I would keep including up to before such as, and add the most. So including persons suspected of or convicted of most serious crimes, period. With regard to the a dignified existence, I agree with Madam Cleveland, everything she said except the conclusion. I still prefer life in dignity to a dignified existence, even though I'm aware that this is the term Inter-American Court used. And, well, I can also go along with the proposal made by Madam Daiva-Fo, but I can go either way. I don't think that we need to go into specifics because we have 28, which will come later. Thank you.
Thank you very much. Mr. Politi, please.
You, Chair, I try not to get into a drafting exercise, although sometimes it's difficult. I want to raise especially 2 points. But to begin with, I agree with Mr. Fatala. The concept of protection of law should go in paragraph 3, in my view. On the question of the terrorist crimes, specifically indicated at the end of paragraph 3, I was among those who suggested or supported the idea. And I keep the suggestion, but if the group feels that it's better to resort to a more general definition, let's say, I would agree with the suggestion of having the reference to the most serious crimes. But I would like to call the attention of the committee on one humble suggestion that I made yesterday, which was the one on not having this difference between entitlement of individuals on the one hand to be free from acts and omissions intended or expected to cause their unnatural or premature death, and the legitimate expectation to enjoy a dignified existence. Why is this difference? I was suggested yesterday to say entitlement instead of legitimate expectation. Now, I was not able to write down the text of what Ms. Cyberforce suggested. It seemed that if it get rid of this difference between entitlement and legitimate expectation, I think it's a path to be worth to be followed. The reason why I have some suspicion towards the concept of legitimate expectation is that we say here the right to life concerns the entitlement, then concerns the legitimate expectation. Now, we know that in reality there are a number of people in the world who don't have many legitimate expectations to enjoy a dignified existence. So I don't want any kind of interpretation that may suggest that the right to life does not concern those people. This is one additional concern that I have, together with the fact that it's, you ask yourself some questions. Why entitlement on one side, the legitimate expectation on the other side? I would be happy maybe to hear again the suggestion by Ms. Cyberfor, and if we can get rid of this different level of protection, let's say, I would be very pleased. Thank you.
Muchas gracias.
Thank you very much, Mr. Politi. Mr. de Frouville, please.
Merci beaucoup, Monsieur.
Thank you very much, Chairman. 2 points on this sentence to come back to what Mr. Politi has just said. I was perhaps a little speedy in my initial explanation. I take on board what he's just said. I myself had thought about this issue of legitimate expectation. I think there are two aspects of content to the right to life. There is the right not to be subject to act or omission intended or expected to cause death, and then there is the right of all persons, not the expectation, but the right of all persons to live in dignity. It's not a legitimate expectation. It needs to be part of the right. We can understand that a right might create a legitimate expectation, but a right is a right in and of itself. My neighbour pointed out to me I'd replaced. Mr. Benachor said the term existence had been replaced with the term life. I think the term existence, as it appears certainly in the initial text, is a little strong. Existence is quite existential. I think life is a better term there. It's more basic, if you will. I don't think we need to ask for a dignified existence, this kind of life affirmation. It's a concept of life which I don't think we need here. I think the term life, dignified life, life in dignity would be preferable to existence. Lastly, to react a little to what's been said by some colleagues, I wonder whether we need to be careful not to go back to the time of the Cold War with strict separations. Our covenant was a victim. At the beginning, there was the Universal Declaration, there was one draft covenant, and then there was the Cold War, and everyone went off with their own covenant and their own concept of human rights. This is a product of the Cold War, and we know since the beginning of the 90s we've got away from that dichotomy. We've moved away from it, and today all human rights, and I will come back to this a bit later, all human rights have 3 levels of obligations: an obligation to respect, to protect from interference from third parties, and to implement all human rights. All human rights encompass the same obligations for states, and these obligations involve the obligation to act or not to restrain themselves, or to take positive measures regarding omission. And omission and acts have the same type of limitation. It's always the same legal regime which applies to omissions and to actions. Our committee itself has acknowledged that, for example, it was counter to the right to life not to do anything to prevent a famine, or not to combat an epidemic, to take no measure by a state to combat an epidemic. We found that that was a violation of the right to life. And I think that the non-derogable character or the nature of the right to life, I think, well, that doesn't change anything. There are absolute obligations in a number of situations, whether they be omissions or actions necessary from the state. Thank you.
Muy bien. Antes de darle la palabra.
Thank you very much. Before I give the floor back to the rapporteurs, Ms. Cleveland, please.
Thank you, Mr. Chairperson. Just with respect to the issue of the right to life being protected by law, I think wherever we include that, paragraph 3 or paragraph 4, we also need to include the other part of paragraph 1 of Article 6, which is that no person may be arbitrarily deprived of life, because that doesn't appear at present until, I think, paragraph 12 of the draft. So the sentence could read, paragraph 1 of Article 6 of the Covenant recognizes that the right to life must be protected by law and that no person may be arbitrarily deprived of life. But I think we need to include both of them. I would still put it at the beginning of paragraph 4 because that's where we're discussing the other limitations, but I would leave that to the rapporteurs. Thank you.
Muy bien, muchas gracias.
Thank you very much. If there's something that I don't envy in this committee, it's the task of rapporteur of a general comment. I express my greatest solidarity to both of the rapporteurs. I'll give Mr. Shani the floor, to be followed by Sir Nigel. Mr. Shani, please.
Thank you. So we have a lot of food for thought, but I think the picture is emerging. So let me share with you how. Let me try to recapture the debate, and let's try to get some resolutions processed. So with respect to the first sentence, I think the discussion is not whether to keep it, but whether to add to it. The dilemma we have is whether we want to refer to the issue of protection by law in the first sentence of paragraph 3, or in the first sentence of paragraph 4. Of course, we deal with the issue of protection by law extensively later on, but I agree that it's important to put it either here or there. My preference would be to follow Madam Cleveland's approach in terms of paragraph 3 describing the general contours of the right, and paragraph 4 being in a way a table of contents which describes but I don't feel very strongly, and if the committee wishes to go in a different direction, it can be easily done. So this with respect to the first sentence. With respect to the second sentence, I want to make a general point, and this is the issue of individuals which had been raised. I understood the comment made by Ms. Albert-Four as asking us to replace, throughout the general comment, I would imagine, the term individuals with the term human beings. This I would have to revert to Sir Nigel and perhaps seek his opinion. I understand that in French this may generate some issues. In English, I don't think it generates that many issues, and I would just draw your attention to the fact that General Comment 35 extensively uses the term individuals. So, so for me this works, but of course this is not a. This is one of the things that perhaps the chair alluded to, that it's a matter of formula. We all agree on the substance. It's the matter of how we do it in terms of the fine-tuning. Now, there were concerns about the term. Madam Cleveland raised the issue of expected, whether the term expected conveys the issue of reasonably foreseen. Again, I will revert to Sir Nigel. In my view, this is exactly what the term expected is supposed to convey, that it's reasonably foreseen. And intended, as Mr. de Fourville mentioned, this means a deliberate measure, act or omission, and whereas expected is something which may not be deliberate, but may lead nonetheless and be expected to lead, or being reasonably foreseen to lead to the same outcome. So unless there is a strong opposition, I think I would prefer leaving this part as is. And I agree with Mr. de Fourville with respect to acts and omissions. I don't think we would want to introduce here a distinction between acts and omissions. I think the same standard would apply. Now, with respect to legitimate expectation to enjoy a dignified existence, I'm comfortable with both proposals that were raised here, that we change the term legitimate expectation to entitlement, and the term dignified existence to a life with dignity. I think in a way they balance out. We are strengthening a little bit the term of entitlement, and we are in a way slightly maybe diluting the term of dignified existence, which may have some French existential meaning to it. So I think this could be for us a good way to proceed. I realized that there was a proposal to talk about the foundation, but the concept of foundation I think properly belongs to paragraph 2, which deals more with the ideological underpinning of the right to life, whereas paragraph 3 deals more with the scope of application. This is why, by the way, they are in 2 separate paragraphs, and upon reflection, I actually think they should stay in 2 separate paragraphs. But this is maybe something the 2 co-rapporteurs will have to fight out later on. With respect to the next sentence, well, I think we have here a few incompatible proposals. My inclination would be, and I think this is where the most speakers have leaned towards, keeping the first segment, which follows without distinction of any kind, namely including persons suspected or convicted of serious crime, but adding the term the most serious crimes, partly to allude to the death penalty issues that we will be taking up. But then, of course, we have to take away terrorist crimes, because we cannot imply that terrorist crimes are necessarily the most serious crimes. So I think this, again, would be a good way to strengthen some part, but on the other hand, perhaps not. Now, I'm very sensitive to the point made by Mr. Benashur, and this is exactly why we brought it in, because we thought this is a real problem in the real world. We were actually struggling with the notion of whether we want to deal with combatants here, but we thought it would overburden too much this introductory paragraph, and upon reflection, maybe the issue of terrorism, which we must deal with subsequently, maybe here it would also distract attention from the more general scope. So my proposal would be to basically add, basically leave the first sentence to deal with the issue of the protection by law in paragraph 4, and to adapt the paragraph with the 3 changes that have been proposed. Entitlement instead of legitimate expectation, life with dignity instead of dignified existence, and most serious crimes instead of just serious crimes. I do acknowledge for Mr. de Frouville that we will have to revert to paragraph 2 and deal with the issue of interdependence. So even if we were to adopt paragraph 2, it would be provisionally until we deal with that issue, with that aspect as well. And I think that in that way we are covering all of the major issues. So now I revert to Sir Nigel, if the chair so permits. Thank you.
Por supuesto.
Yes, of course.
Que Sir Nigel use la palabra.
Of course, I'll get the floor to Sir Nigel. You have the floor.
Thank you, sir. I think one of the lessons we may end up learning from this exercise is that having 2 rapporteurs is a bit cumbersome, if nothing else. By and large, I agree with what Mr. Shani has said. I still need to think a bit. First of all, I'm not as clear as he is that there is as much agreement as I didn't detect as much agreement as he did, though that doesn't mean I don't think we can't find the language to try and reconcile the positions of colleagues as long as everybody's prepared to swallow reasonably hard. But if we keep going back to ideological discussions about the Cold War and the fact that we're interpreting one covenant rather than two covenants, then we can have those discussions, and I'm capable of engaging in them, and I'm not prepared to let my position as co-rapporteur prevent me as an individual member participating in those discussions. The fact remains, I don't think it's terribly productive. We're interpreting our covenant in the context of the way we have traditionally interpreted it, including for the 20 years since the end of the Cold War. Again, I repeat that I do not believe that the right to life is therefore an umbrella for all the other rights in both covenants. And if I don't see how we can draft a general comment on the right to life that starts from that premise. I also don't see the point of continuing that ideological discussion. But there's also a consequence, and that is any reference to interdependence has to be one that is consistent with what we've already agreed and what previous committees have already agreed, is that the right to life is the supreme human right. As for the rest, I think we're going to have to do our best to try and come up with a text. It might even be that there'll be another paragraph just essentially reasserting paragraph 1 of Article 6, so that then becomes the umbrella for the rest. Let's Mr. Shani and myself take a look at that. I don't think there's anything in there, the idea of including protection, although we deal with that, of course we deal with that in detail, and I'm grateful to Mr. Sital Singh for making the point in great detail later on in the text. I don't see there's a problem of including both the notion of ruling out arbitrary deprivation of life and the obligation to protect life, and putting that very, very high up as chapeau, even if it means repeating the language of Article 6, paragraph 1, which wouldn't make this the first general comment to have done precisely that. Thank you very much, sir.
Muchas gracias.
Thank you, Sir Nigel. Mr. Fatala has sought the floor. Mr. Fatala?
Thank you, Mr. Chairman. I agree with the summary made by the two rapporteurs and some conclusions, but we will be waiting for the new drafting. But I'll go back again to my proposal or my comments on Mrs. Cleveland concerning the issue of the right shall be this right, which means the right to life, shall be protected by law. I propose it in 3, not in 4, because in 4, as I said, we are making reference to paragraph 2, 4, 5, and 6 of Article 6, and all these are related to specific safeguards and to the death penalty. But the issue of the right to life to be protected by law is not only linked with the death penalty. If you look at Article 6 from paragraph 2 to paragraph 6, they are just speaking about death penalty and not in general the right to life. Thank you, Mr. Chair.
Muy bien, muchas gracias.
Thank you very much. Mr. Bouzid, please.
شكرا سيد الرئيس. لا أظن أني
Thank you, Chairman. I do not think I received a response following the proposal that I made. We are discussing the question of dignified existence, and that would presuppose obligations on states. And I was making a proposal with regard to the expectations of states in terms of dignified life. Thank you.
Muy bien, muchas gracias.
Thank you, sir. Mr. Shani, please.
Yes.
Thank you. I think actually the proposal just made by Sir Nigel that we add another paragraph would take care of both of Mr. Fatala and Mr. Bouzid's observations, because paragraph 3 doesn't deal with the obligations of states. It deals with the scope of the issues which Article 6 address. But if we have another paragraph which 3 bis, I guess, which introduces the chapeau, the Article 6.1 chapeau, and deals with the obligations of state, both the negative obligations and the positive obligations that pertain also to the duty to protect life. I think this would take care of these issues, but of course this is something that we will have to bring before the committee, and that's also in a way splitting the baby in half, so we don't have to decide whether it's 3 or 4. It will be in between 3 and 4 as a separate. That's a very Solomonic solution, I guess. I hope this is acceptable to all members. Thank you.
Gracias, Sir Nigel.
Thank you, Sir Nigel.
Thank you, sir. I'm sorry I didn't mention Mr. Bouzid's name when I thanked Mr. Situl Singh for pointing out that paragraph 28 and follows deals exactly with the kinds of issues that Mr. Bouzid is talking about, so that it has to be precisely the general language of protection up here right at the beginning, and then we spell out what protection means when we get to the section on protection, which starts at paragraph 23, section 3. There's a whole section on protection, and we have to read the general comment will have to be read as a whole, and so it is only the general language of protection that belongs up here in these preambular paragraphs, as Mr. Shani is suggesting, and I also agree with him that some sort of Solomonic division of paragraphs may be the solution. I myself, in fact, do agree that we should be separating out the basic obligation in paragraph 1 from the clawback paragraphs in paragraphs 2 to 6. I actually disagree with the idea of keeping them together. Thank you.
Muy bien, muchas gracias.
Thank you very much, Sir Nigel. When we adopted General Comment 35, I recall that the rapporteur listened very patiently to all of our comments, including mine, and at the end we were told, well, the fact is that's included further down in the text in paragraph X or Y. And I think it's important for us to ensure the necessary distance. We need to look at the text as a whole, rather than trying to ensure that everything is said throughout the text. We need to read the general comment as a whole. At this point, I don't think we can ask the rapporteurs to come up with a paragraph 2 and 3 or a merged paragraph. I think they now have sufficient food for thought to work on this and come back to us with 1 paragraph or 2 for the forthcoming meeting on this issue. I would ask committee members, unless they feel there is something absolutely fundamental that is not reflected in the new drafting being proposed by the rapporteurs, that we try to make some progress. Fine. Thank you very much indeed to all of you. Thank you also to the rapporteurs, of course, for their work. And thank you for taking into account all of the comments from colleagues. Let us now, on a provisional basis, move on to paragraph 4 of the draft. And I'm going to give the floor first and foremost to the rapporteurs, starting with Mr. Shani.
Yes, this will be very brief. Paragraph 4 is, as I said before, is in the form of a table of contents, which introduces the contents of what is included in these paragraphs. It is supposed to be descriptive and not prescriptive, but I look forward to comments that you may have. And of course, I would ask Sir Nigel to add his observations.
Sir Nigel?
No, this is a good example of really essentially repetition. We don't need to. This is just scene setting. We deal with the death penalty later on. We're just flagging the structure of Article 6 at this preambular stage. I will, however, at the risk of doing something I disapprove of, and that is make a little suggestion, a drafting suggestion that I haven't, I think, covered with Mr. Shani, and that's where we say in the second sentence, additional limitations on the ability of states parties to apply the death penalty are found in Article 6. At best, I think we should be saying 6 paragraph 1. At best, we should be saying contained in, because, in fact, Article 6 paragraph 1 doesn't explicitly refer to the death penalty at all. And so, to the extent that Article 6.1 is relevant, it's because of what may be implicitly contained rather than clearly found by the untutored reader. Thank you very much, sir.
Muy bien, muchas gracias.
Thank you very much. I now have some requests for the floor from committee members, 3 to be precise. Mr. de Frouville, please.
Merci beaucoup, Monsieur le Président. Alors...
Thank you, Chairman. A great deal has been said already, and that makes things easier. As I understood it, Sir Nigel indicated that in this article we would not be dealing in substantive terms on with the death penalty, but form and substance are linked. This is a descriptive article, but I think that we might wish to evoke the specific structure of Article 6, which sets it apart, and I wanted to mention that in my intervention. I also think, as I said, that there's a need for a separate paragraph on Article 6.1, which has quite wide-ranging normative powers and deserves consideration in a 3 bis with regard to protection of the right to life from arbitrary deprivation and the applicability to the specific regime of the death penalty. There is also 3 with regard to the crime of genocide. This could be considered either in 4 or in a standalone paragraph. I'm not sure for the time being. I simply wanted to throw that out there for the time being. With regard to paragraphs 2, 4, 5 and 6 of Article 6, I think what needs to be stressed in the interaction between these paragraphs is, firstly, the drafter's intention not to set up a system whereby the right to life is limited in some way, a restrictive system, rather a quasi-derogatory system. In other words, not so much suggesting that the death penalty is a legitimate limitation on the right to life, rather indicating, as in paragraph 6, prior to the abolition of capital punishment, a very strict framework should be established for its application, as is done in international humanitarian law in terms of warfare. Killing in the course of warfare is not sanctioned as such. It's limited, considering that it's a necessary or a reality. I think there's a need to stress that 6 is a derogation from the right to life, which is very carefully framed and has been by the drafters of this with a view to eventual abolition. I'm going to read my proposal in French. I will try to ensure that the English version reaches the rapporteurs also, and it would be as follows. Paragraphs 2, 4, 5 and 6 of Article 6 of the Covenant set out specific safeguards for ensuring that, and here we'd add, in countries where the death penalty has not yet been abolished, this not be applied except in the most exceptional circumstances and subject to very strict restrictions. I'm not going to engage in a drafting exercise, Chairman. I'm just going to continue and suggest that in a following sentence we could stress that paragraph 6 specifically, and I'm getting into substance here, but paragraph 6 indicates that these limits should not be construed as a means of delaying the abolition of the death penalty. In other words, these provisions govern the transition away from the death penalty for states who have the death penalty in place but who have ratified the covenant, and in so ratifying are bound to eventually abolish it. Thank you, Chairman. The Chairman, thank you very much indeed. I have 5 speakers on my list. We have 15 minutes remaining. Mr. Sital Singh, please.
Thank you, Chairman. Sir Nigel has just pointed out to the second sentence. In fact, I have a brief comment on this word additional limitations on the ability of state parties to apply the death penalty of in Article 6, Paragraph 1. I'm fully aware that the whole topic is dealt with in Chapter 2, which is the prohibition against arbitrary deprivation of life. But in Paragraph 4 itself, I would prefer, instead of just referring us to Article 6, Paragraph 1, I would have preferred this sentence to say that state parties shall not apply the death penalty in an arbitrary manner. And I'm of the view that this would cover our concern, because in Article 6, Paragraph 2 of the Covenant, of course, the important words are in accordance with the law. But then it may happen that in any particular state, the law may still be applied in an arbitrary manner, or there may be laws which are arbitrary. So I reiterate my proposal here to say that state parties shall not apply the death penalty in an arbitrary manner as provided for in Article 6, Paragraph 1, or something to that effect. Thank you.
Muchas gracias, señor.
Thank you, Mr. Politi, please.
Thank you, Chair. I can really be brief because Mr. De Fruville has said very eloquently, has expressed the concept that I wanted to put forward before the committee on paragraph 4. And I'm also attracted for Mr. Sital Singh has just suggested. If you forgive me, and I apologize for that, if I can make also a drafting suggestion. There is a reference to the to ensuring that where national and international legal instruments do not totally prohibit death penalty, it shall be exercised only in the most exceptional cases and under the strictest limits. In other paragraphs of the draft comment, I think that the reference is to the most serious crimes. Maybe we can adapt the text also here to the idea of the most serious crimes, and maybe subject to a number of strict conditions, something like that. I think there is a paragraph afterward, paragraph 20, where this expression is used instead of the one that is currently in paragraph 4. Thank you.
Muchas gracias, señor.
Thank you very much, Mr. Politi. Mr. Fatala, please.
Thank you, Mr. Chairman. Mr. Chairman, I would like to see the deletion of the sentence, the second sentence, which is additional limitations on the ability of state parties to apply to death penalty, are found in Article 6, paragraph 1, because we will be, or the two rapporteurs will be drafting a new paragraph covering all the elements of Article 6, paragraph 1. And this will be a kind of chapeau. It will be preceding this paragraph or even paragraph 3 and 4. And therefore, I don't see any need to have this sentence. And I agree with Mr. de Fourville that we can add what he mentioned, and I read it in French, dans les pays où la peine de mort n'est
In countries where the death penalty has not yet been abolished, and so on.
Sentence of paragraph 4, and also with the proposal of Mr. Situl Singh he just made. Thank you, Mr. Chair.
Muchas gracias.
Thank you, Mr. Fatala. Mr. Rodriguez-Recia, please. Thank you, Chairman. I had not intended to speak to this text. I think it is a good text. I would agree with what has been said by previous speakers. I simply wanted to draw attention to a point. Given that the paragraph makes reference to the Convention on Genocide, in brackets here, I would like to dwell on the notion of massacres, because there is a distinction between genocide and other acts which cannot be qualified as genocide for political reasons, such as massacres, which fall outside the scope of that convention. So at some point we will have to look at that distinction. Either we turn a blind eye to it, or we look at those massacres that cannot be qualified as genocide under Article 5 and the ways, or paragraph 5 rather, and other ways in which life, the right to life, may be denied. Thank you.
Perdón. Muy bien. Muchas.
The Chair, thank you very much indeed. Mr. Iwasawa, please.
Thank you, Mr. Chair. I'm addressing the first sentence along the same lines as Mr. de Fourville and Mr. Politi. The language in this first sentence, following ensuring, it's to me it's a bit awkward, because it says where national or international legal instruments do not totally prohibit the death penalty. I do understand that the international legal instrument do sometimes, in some instrument, prohibit the death penalty, but it's awkward to say national instrument prohibit the death penalty. I think countries where death penalty is not prohibited, that's what we want to say. So I support the idea of reproducing the language in Article 6.2, namely ensuring that in countries which have not abolished this penalty, sentence of death may be imposed only for the most serious crimes, because the current text also says it shall be exercised. I think it takes to me. I take it that it means that this penalty shall be exercised. It sounds odd to me, so I support the idea of using the language in 6.2. And 6.2 doesn't have this little bit at the end, under the strictest limits. I have no problem of adding this and under the strictest limits. Thank you, Mr. Chairperson.
Bien, muchas gracias.
Thank you, sir. I'd thought that there was a problem with the Spanish text. It appears to be an issue with the English also, the notion of exercising the death penalty. In fact, it's applying the death penalty. I just wanted to mention that point. I would like to give the floor back to the rapporteurs to hear their reactions to colleagues' comments. Sir Nigel first.
Okay, I'll go first on this, but everything I say is subject to Mr. Shani. And I'm not going to say a lot, because I agree with most of what has been said. To some extent, I think we've been trying to avoid just repeating the language of the covenant. But in trying to do that, we haven't always faithfully reflected what our own reading is, which is an abolitionist reading of the covenant. And that comes out very clearly, I think, when you get to paragraphs 52 and 53, where there'll be no ambiguity at all about the rapporteur's approach to the death penalty as a relic that shouldn't have too much life left in it, and indeed as very much an exception, a necessary exception to a right to reflect state practice of the time, but nevertheless not something that was inherently desirable. On the contrary, as our predecessor committee said as early as 82, clearly the Covenant found it undesirable that there remain the death penalty. So all of the proposals going in that direction will be fine for us, I think. Whether the wording that everybody has used will work, we'll have to see. We'll do what we can, but there's absolutely no harm in, on the contrary, signaling this early what we say much more firmly later, namely that the death penalty is a legal embarrassment that we hope is on the way out. And I don't think I can say it any more strongly than that. Thank you very much, sir.
Muchas gracias, Sir Nigel.
Thank you, Sir Nigel. Mr. Shani.
Well, I fully agree, and I think we will take on board all comments. I have 2 points which I want to raise. First, well, 3 points. First, the strictest limits. This is a response to Mr. Iwasawa. Yes, of course, it's not taken from section 2, paragraph 2, because it is supposed to encompass paragraph 2 and 4 and 5. So the strictest limits actually is a common denominator to the various conditions which are found in other articles, including, in fact, the most serious crimes. So the most serious crimes actually falls within the strictest limits, and it's also a little bit a stylistic matter. We have used the term most serious crime in paragraph 3, so I'm not sure whether we want to use it again, but it's really not, if it's important for members, we will keep it in. Now, with respect to the point Mr. Fatala said, I think this is the more difficult point, because analytically, Mr. Fatala is correct. Once we use the chapeau, which covers everything, then it appears to be redundant to repeat it. But my inclination would be to keep it nonetheless, in order to avoid the argument, the not very convincing argument, but the argument that we may encounter that these are lex specialis provisions. So we want to underscore that the general standard also applies to the more special provisions. So I think it wouldn't do harm here to repeat it, and it may generate some confusion if we don't. So I would, barring this last remark, I think we have enough information to produce a draft section that would reflect the discussion. Can we adopt 7 now?
No, vamos a... No creo, vamos a...
I'm not sure about that. Sir Nigel, sought the floor first.
Just one word on the sentence that Mr. Fatala proposed we delete. I think it can't survive in its present form. The point that we were seeking to make is that it's not sufficient for states just to comply with paragraphs 2 to 6, that there's more to it than that. But we don't do it so felicitously, which was in a way why I suggested putting contained rather than found, but I still think the paragraph is a bit opaque as it is, and we might try and find another way of articulating the point that Mr. Shani quite rightly wants us to continue to make. Thank you, sir.
Muy bien.
Very well. Thank you very much indeed. That has been a very enriching debate that we have held this afternoon, a very valuable one. The rapporteurs will have a great deal of homework to get through, and they won't have much time to do it because on Friday afternoon at 4 p.m. we will be further considering the general comment. I would like to see us adopting some paragraphs on Friday afternoon, if possible. When Mr. de Fruville talked earlier on about the right to life of legal persons, I realised that we forgot to mention that this week is the 70th anniversary of the UN. This was marked a few days ago, and I think this organisation, which is housiest, deserves congratulation. An opinion from the ICJ, giving legal personality to the UN for reparation of harm in service of the UN is something which seemed to be guaranteeing the right to life of the international organisations, and I think given that the UN is now therefore a legal person, we should celebrate the UN. Of course, the UN doesn't achieve all of its objectives, but without it, the world would be a far worse place. It is up to us, therefore, to pursue the objectives of the United Nations, international cooperation to promote and protect human rights among them. And on that happy note, I would like to close today's session. Thank you very much indeed to you all. Tomorrow, we will be meeting in closed session to study communications. Could I remind colleagues, therefore, that we will be continuing with communications? Thank you very much indeed to you all. Thank you to conference services, the Précis writers, interpreters, members of the Secretariat. Enjoy your evening, everybody. See you tomorrow.